Federal judge calls out Prudential Insurance Company's failure to provide a denied ERISA policyholder a copy of her claims file. I'm sure that you, like many, purchased a disability insurance policy through your employer to provide you with financial peace of mind if you became disabled. Now, what has happened to you? I have to tell you that you have had your worst nightmare come true. And you need to understand that carriers like Prudential are not in the business of honoring the promise that they made to you when they sold you the disability policy. They will often delay, deny, or even terminate claims, hoping that you will simply go away. Under the ERISA regulations, you, the policyholder, have to file an appeal within 180 days of a denial, or the carrier can argue that once suit has been filed, that you have not exhausted your administrative remedies. One of the basic principles in ERISA law is that the claimant has to exhaust those administrative remedies and file an appeal before they can go into federal court. But what happens if the disability carrier fails to comply with the ERISA regulations that require them to produce a copy of your file? Let me tell you the story of Ms. Lejeune, whose claim for disability benefits were denied. She made multiple requests for a copy of her file. Prudential failed to provide her with that file. So she said, "Nuts to you," and she filed a lawsuit in federal court. In support of her claim, she attached affidavits from her lawyers who confirmed their unsuccessful multiple written requests and phone requests for a copy of her claim file, and their failure to ever receive it before they filed a lawsuit. So Prudential, of course, said, "Look, we want you to affirm that claims denial. She hasn't exhausted her administrative remedies. Judge, we want you to kick her out. The time is run. She's done." So what are the obligations of a disability insurance company under the ERISA law? ERISA law will govern most group-issued employer policies or plans, and it requires that the claim appeal process give you a reasonable opportunity, if your claim has been denied, for a full and fair review. Section 113 of the ERISA statute and the corresponding regulations require that a plan or policy do the following. 1, they have to provide adequate notice of the right of appeal. 2, they have to do it in writing. 3, they have to set forth the specific reasons for the claim's denial. And 4, they have to provide that notice in a manner calculated so that you can understand it. And number 5, they have to advise you that you have an opportunity for a full and fair review of your claim. And if they don't, there are some penalties. Now, it's impossible to write an appeal letter if you don't have access to the carrier file and all of the documentation that they relied on in denying or terminating your benefits. What Prudential did was to try to pull a fast one. They argued to the court that it had produced over 1,000 pages of file material before the appeal period expired. Now, Lejeune's attorneys contradicted that claim, and Prudential never ever offered any proof that in fact they had sent the record. And even if they had, it would have been impossible to write a meaningful appeal letter if it hadn't been timely submitted to the attorneys. After all, the ERISA statute says the appeal has to be filed within 180 days and not 14 days prior to the deadline, as the carrier alleged. So what did the court have to say? Well, the court wasn't happy. In the case of Lejeune versus Prudential, in this Louisiana case, the judge told Prudential that Lejeune could file an appeal of her claim based on the entire administrative record and threw out all of the claims denial. The judge agreed that she never had a full and fair review without access to the carrier's file, and even if she had gotten it 14 days before the hearing, that was not enough time. That was a great win. So what should you do if your claim for disability insurance benefits have been denied? You should contact me. I'm a nationwide disability attorney who can help you get the ERISA disability benefits you deserve, regardless of where you live in the United States. I've taken on many disability carriers, and I'm not afraid to be in federal court. Remember, you'll only have 180 days in which to file an appeal of your ERISA denied or terminated claim. If you don't, you lose, and you don't want to give the carrier an easy win. Call me today at 727-894-3188 to schedule your free 30-minute consultation. I look forward to helping you get the disability benefits you deserve, regardless of where you live in the United States.